Hello guys, welcome to our YouTube channel Enlighten UPSC and PSC. Today we are going to discuss Article 22 of the Constitution, which is regarding the safeguard against arrest and detention. When a person gets arrested or detained by the executive authorities, what rights or safeguards will he have under the Constitution? That is our today's topic. So let us discuss it. First of all, what is the difference between arrest and detention? What is the difference between arrest and detention? In case of a person being detained, he is not formally accused of committing a crime. See, if a person gets arrested, it means he is accused of or alleged to commit such a particular crime. But whereas detention is different. In detention, he is not formally accused of committing a crime, but simply restricted and kept in police custody on a reasonable suspicion. So he will be he will be detained for the reason of reasonable suspicion of committing a crime. In custody, she or he is questioned or investigated by the police authorities or the investigating agencies. After the police questioning the person detained would be released. He will be released. After questioning him, he will be released. Whereas a person can only be arrested if he is charged for a crime. And once he is arrested and he has to be produced before the magistrate within 24 hours. In certain situation, an initial detention may lead to arrest. During the time of custody, he would have the right to consult a lawyer of his choice under Article 22. See, in case of arrest or detention, if a person, for example, a person A was detained for questioning not on a reasonable suspicion, but a certain way of using police power in order to restrict him. If the police restricted him and by that restriction he got any loss in his business or any other thing, then the law of torts compensation would apply, which means if he files a case against the police and claims for a compensation because he was arrested or detained on an unreasonable suspicion, he can claim compensation as well. This has already happened in the past. Arrest. Regarding arrest, the National Police Commission report says 60% of arrests were unnecessary and unjustified. The power of arrest became a chief source of corruption to the police. So, police have been using the power of arrest. Most of the arrests are unnecessary and unjustified. In Joginder Kumar vs. State of UP, Supreme Court held a person cannot be arrested merely on the suspicion of complicity in an offence. There must be some reasonable justification in the opinion of the police officer that such arrest was necessary and justified. So you cannot simply arrest just merely on being suspicion. There should be a reasonable suspicion, a reason behind for his suspicion. That is very important in case of arrest. So the next topic is, what is the difference between police custody and judicial custody? This was asked in last year UPSC civils exam. In case of police custody, police or investigating agency will arrest and put in lockup. Whereas in judicial custody, he will be kept in jail, not in lockups. Judicial custody will be announced by the magistrate only, not by the police. The police or investigation agency can only lock up in the police custody. When a person got arrested or detained in police custody, it is mandatory for the police to send to the magistrate within 24 hours. When the police arrests or detains a particular person, the police has the constitutional duty to submit the accused before the magistrate within 24 hours time. Magistrate can extend the police custody to till 15 days. It is basically, if a person get arrested when the investigation is not completed, cannot be completed within 24 hours, then police will request the concerned magistrate to extend the police command. Will request the magistrate to extend the police custody. Then magistrate can extend up to 15 days. Even after 15 days, the police requests again to the magistrate to extend the police custody. It is not possible. Then in that case, magistrate will impose the judicial custody, in which he will be kept in jail, and the security agencies or the investigations agencies can interrogate the concerned accused only on the permission given by the magistrate. The judicial custody can extend up to 90 days and 60 days. 90 days in cases which have punishment for more than 10 years. For suppose a person is accused of a crime, say murder, if such punishment is proved, then if at all he can be arrested or imprisoned for more than 10 years, or for imprisoned for life, or a death sentence is given, then 90 days judicial custody can be extended by the magistrate. In case other offences, 60 days is the period of judicial custody. In case of police custody, police can interrogate without magistrate permission, but in judicial custody, only magistrate has the right to interrogate. Okay, this is the difference between police custody and judicial custody. Article 22 says, if a person gets arrested or detained, he should be informed the grounds of his arrest. So, as soon as a person gets arrested or detained, he should be informed the grounds for his arrest, on what basis, on what facts he got arrested, and he will have the right to consult and to be defended by a legal practitioner of his choice. It is basically a lawyer. He will have the right to consult and defended by a lawyer of his choice. And the third thing is, after his detention or arrest, the police will have to produce within 24 hours before the nearest magistrate. In calculating these 24 hours, transportation or journey time will be excluded. In case, I already said, in case if it can be, I already said that in case the police want to police custody more than 24 hours, then only under the authority of magistrate they can do so. Only if magistrate gives permission, then they can extend the police custody beyond 24 hours. It is very important to note that this particular article 22 also available to a person arrested under the warrant issued by the speaker of a legislature for contempt of house. If you want to know about this particular point, see my last lecture on privileges of the parliamentary privileges. Okay. Right to defend by a lawyer. I already said if a person gets arrested, he has to be informed about the grounds of his arrest, and he will have the right to defend by a lawyer of his choice. See, prior to Menaka Gandhi case 1978, courts in India were of the opinion that it was not bound to provide help of a lawyer unless a request is made by the concerned accused. But after the case, the courts are bound to provide assistance of a lawyer to a person arrested. In Husainara versus Home Secretary State of Bihar 1979, it is as Supreme Court held that it is both a constitutional right of every accused to engage a lawyer, and it is the constitutional duty of the state to provide a lawyer to a person if he is unable to engage a lawyer because of financial constraints, etc. This is very, very important case. Husainara versus Home Secretary State of Bihar 1979, in which Supreme Court held it is both a constitutional right and a constitutional duty. Article 22 available to both citizens and non-citizens. For example, the Taj Hotel terrorist Mohammad Kasab. In his case, what had happened is that initially Kasab refused to defended by a lawyer. He thought the Pakistani government will send a particular lawyer or appoint a particular lawyer for him. But as this did not happen, he again requested the government of India for a lawyer. So they provided him with a lawyer. So it is both right for citizens and non-citizens as well. In A.S. Muhammad Rafi versus State of Tamil Nadu, what had happened is that a bar association, the action of bar association in passing a resolution that none of its members will appear for a particular accused, whether on the grounds he may be a suspected terrorist, a rapist, murderer, mass murderer, etc., is against all norms of constitution, the statute and professional ethics. Here the Supreme Court held that if the bar association, the lawyers association, refused to attend for a particular case, if such person is a suspected terrorist or a rapist or mass murderer, it is against all norms of the constitution, statute and professional ethics of passing such a resolution. This particular Article 22 will not apply in certain cases. So if a police removed a minor girl from a brothel house, a prostitute, then it does not amount under arrest and detention under Article 22. At the same time, the arrest of an abducted person, the arrest of an abducted person was held not to constitute arrest and detention because the person was not accused of any offense of a criminal or quasi-criminal nature. Article 22 doesn't apply to a person arrested under a warrant issued by the court. See, if the magistrate gives warrant to arrest a particular person, then the person cannot claim protection under Article 22. Okay. Article 22 is designed to give protection. You see, it is very important. This particular article gives protection against the act of executive order or order of non-judicial authority, but not judicial. Okay. This is designed to give protection against the act of the executive order or order of a non-judicial authority and applied to a person who has been accused of a crime or of an offense, criminal or quasi-criminal in nature, or some act prejudicial to the state or public interest. No, this is not against judicial order. Article 22 subclause 3, just a minute. Article 22 subclause 3, it says that clause 1 and clause 2, clause 1 is nothing but to inform the grounds of arrest. Within 24 hours he should be submitted, and this is about right to be defended by the lawyer. This doesn't apply to any person who is an enemy alien or who is arrested or detained under preventive detention laws. If a person gets arrested under preventive detention law, he cannot claim the rights under Article 22 subclause 1 and 2. Okay. So what is PD acts or laws? Preventive detention. What is preventive detention? See, there is no authoritative definition for the term preventive detention. The word preventive is used in contradiction to the word punitive. While the object of punitive detention is to punish a person for what he has already done, the objective of preventive detention is not to punish for having done something or wrong, but to intercept him before he does it and prevent him from doing. So if a person commits a crime of a murder, then he will be get arrested and imprisoned. That is punitive detention. But even before he commits a crime, if the police arrests and detains him, then it is called preventive detention. Okay. See, in the case of Union of India versus Paul Nanikan and another, the Supreme Court stated that the purpose of preventive detention is not to punish a person for doing something, but to abstract him before he does it and deter him from doing so. The reasoning for such a detention is based on suspicion or reasonable possibility and not criminal conviction, which can be justified only by a valid proof. This is very important. Under section 151 of CRPC, a police officer can apprehend any person without magistrate authority, without a warrant, if he receives any information that the person is likely to commit a crime of cognizable nature and which cannot be prevented otherwise. These preventive detention laws are absent in democratic countries. Yes, this is true. Preventive detention laws, you will not find preventive detention laws in a well democratic countries. No country in the world had made these laws integral part of the constitution as has been done by India. See, there are no such laws in USA, but there are such laws in England, but they are used only during time of war. But India is the only country which have these laws and has made these laws integral part of constitution. Indian constitution, however, recognizes PD in normal times as well. In England only during war time, but in India in normal times as well, the preventive detention laws are recognized. In A.K. Gopalan versus State of Madras case, it is said that we know these PD laws are a sinister looking feature which obstructs the fundamental rights, but these are doubtless designed to prevent abuse of freedom by anti-social and subversive elements. So their rights, their freedoms may be misused by some anti-social and subversive elements which might imperil the national welfare of this republic. Punitive and preventive detentions were outside Article 19. We all know that. See, clauses 4, 5, 6, 7, 8 of Article 22 deals with preventive detention. See, as I already said, clause 1 and 2 doesn't apply to an alien enemy and a person who was arrested under preventive detention laws. Even under preventive detention laws, no detention for longer period than 3 months. No person can be detained for more than 3 months under preventive detention. But this was reduced to 2 months by 44th Constitutional Amendment. But still, a 3 months only is in force, because 44th Constitutional Amendment regarding this has not yet into force. So, even under preventive detention laws, you cannot detain a person under PD Acts not more than 3 months. But if you want to extend this preventive detention more than 3 months, only under 2 situations it will be possible. One is that advisory board. An advisory board will be constituted, which was consisted of High Court judges. If they feel that there is a sufficient cause for such detention, then the board can extend the detention more than 3 months, but not beyond the maximum period as set by the Parliament. The Parliament will mention as time period, the maximum time period for a detention, or the detaining authority will also say. And the second exception is that if such person detained by law made by Parliament, in this case permission of advisory board is not required. Suppose Parliament makes any law stating that for particular case or cases, or particular crimes or particular cases, there is no you can extend the detention to more than 3 months, and maximum period also will be specified by the Parliament. And in such cases, even you can extend more than 3 months, you need not require the recommendation or approval from the advisory board. So in this case also, the 3 months, it is more than 3 months period. So in both these cases, you can extend the preventive detention more than 3 months on advisory board decision and under law of Parliament. But this particular power to the Parliament was removed by 44th Constitutional Amendment. The advisory board is bound to submit the report before 2 months period. 2 months period in the sense 3 months or 2 months. The advisory board is required to submit the report before 2 months period. Failure to do so would render the detention illegal. See, if a person was detained under a law and the detaining authority provides required information, and based on which the advisory board will take decision and submit a report. If this particular period should happen within 2 months, the advisory board will have to submit its report before 2 months. If at all they fail to do so, then the detention will be declared as illegal. If advisory board accepts a detention beyond 2 months, the detaining authority will determine the period of detention. See, Article 44 has yet not been enforced. Article 22, Clause 5. Article 22, Clause 5. It imposes obligation on the detaining authority to furnish or communicate to the detainee the grounds for detention as soon as possible. As soon as possible is very important, because there should be immediately after he gets detained under PD Act, he should be informed, and it is an obligation on the detaining authority to communicate the grounds as soon as possible. What should be informed to him is that all facts and materials which influenced the detaining authority in making such an order must be communicated, because only based on such complete facts and materials he can understand is the grounds of his detention and also appoint a lawyer before the advisory board. The ground of detention should be very clear and easily understandable by the detainee, because on these facts enable the detainee to make effective representation. So the grounds should be very clear. See, in particular this case, Lalubhai Jogibhai Patel case, communicate, here the word communicate or furnish is a strong word. It requires sufficient knowledge of the basic facts constituting the grounds should be imparted effectively and fully to the detainee in writing in a language he is understood. So if a person A, suppose he hails from Gujarat, he know only Gujarati. Suppose the detaining authorities gave him the grounds of his detention in English, then it doesn't apply. It doesn't apply even though it was given in English and explained to him. The court held that it should be submitted in a language understandable by him. That is very important, and that too in writing. That is very important. So writing is very much important. Why required to communicate as soon as possible? Why you should communicate as soon as possible? Because it acts as a check against arbitrary exercise of power by the executive. Detaining authority cannot whisk away a person and put him behind bars at its own sweet will. It must have grounds for doing so. One point is that. Second thing is that the detainee has to be offered an opportunity of making a representation against the order of detention. Both the cases. It is the duty of the detaining authority to inform that he has the right to make representation against such order and also a right to be heard by the advisory board. See, the person accused may not know his rights. So it is obligation and duty of the detaining authority to inform him that he has the right to make a representation and be heard by the advisory board. But you have to understand one thing here. In a particular case, see, when the detainee is an enlightened person, in a particular case what had happened is that he is a politician, is a senior politician, got detained. The police, the detaining authority have not informed about the rights to make representation. The court held that even though the detaining authority did not mention him or did not inform him about the rights he had to make representation, the court held that this person is an enlightened person and has been in politics and therefore is fully cognizant of his right. Failure to comply with will not make his order invalid. So this is the judgment of Supreme Court. This is it for today. Please subscribe to our channel. Thank you. We will meet in the next lecture.